आपको भेजना है और
क्या
PDF
पिछली बार वो गणित
ना कोई भी बता
ये आप किस उस पे कर रहे हैं? ये वो मूव वाला अकाउंट है।
अच्छा यूट्यूब पे
Jonas from Punjab University.
I think let's continue. You carry on, Samiksha. I think there's some technical problem. We can sit down. Thank you.
We apologize for the inconvenience. Ladies and gentlemen, we are delighted to have Dr. Balram Gupta with us. We have with us our respected Chief Guest, Honorable Justice Anuj Chittara, Judge Punjab and Haryana High Court, and our esteemed keynote speaker, Dr. Gaurav Bhatia, Advocate Supreme Court of India. I present Professor Dr. Shruti Devi, Professor Dr. Ratan Singh, and Professor Dr. Jayamala to felicitate our dignitaries.
So here, honoring you.
The advent of artificial intelligence. The advent of artificial intelligence has revolutionized industries, economies and societies at an unprecedented pace. Yet, amidst this rapid transformation, we find ourselves confronted with profound questions about the compatibility of AI technologies with the principles of constitutionalism and rule of law. Throughout today's proceedings, we will delve deep into these critical questions. Our esteemed panel of speakers, hailing from various disciplines and backgrounds, will offer insights, share expertise, and provoke thoughtful discourse. Together, we will navigate the ethical, legal, and societal dimensions of AI's influence on constitutionalism and rule of law. With that said, I invite the head of the department, the head of our family, Professor Dr. Shruti Devi, Director URLS, to deliver the welcome address.
Good morning, everyone. Honorable Justice Anuj Chittara, Professor Balram Gupta, Dr. Gaurav Bhatia, our keynote speaker, Professor Ratan Singh, Professor Jayamala, Dr. Supreet, Dr. Nidhi, Mr. Lateef, Mr. Amit, my very dear faculty colleagues who are sitting here, the organizing team of this event headed by Yajur, Samiksha, and Swastik and Rajat, my dear participants and very dear students. I welcome you all to this two-day international seminar on the impact of artificial intelligence on constitutionalism and rule of law, being hosted jointly by the University Institute of Legal Studies, Punjab University, as well as Mississippi College of Law from USA. Unfortunately, we could not have their professors be here physically, but they would be joining online for the panel discussions tomorrow evening. being a lawyer has always been a profession which brings with it many different avenues which get opened for us. And I feel that it is a coveted profession because a lawyer gets to smile at people, and even those people who do not like you. So as a lawyer, we are supposed to carry our form and our wisdom and our character with great dignity and poise and confidence, and most of all, the wit. Well, because of that, I really wonder if AI would ever be able to take on the role of a lawyer. And that is what we are gathered here to discuss. Today is 29th of March 2024. Precisely 1 year ago, on 27th of March 2023, the Punjab and Haryana High Court delivered a judgment on a bail order using the AI chat box bot ChatGPT. And it was delivered by none other than Honorable Mr. Justice Anup Chitkara, who sits here as the chief guest for the program today. He posed a question to ChatGPT to throw up and propound the jurisprudence on bail, its values, and at what times can it be used, and in the different arenas that it can be used. Well, he came up with a great answer, because in Jaswinder Singh versus State of Punjab last year, he denied the grant of bail to the petitioner and his accomplice on the ground that they were responsible for attacking and killing the victim. But more importantly, Justice Chitkara understands that AI is merely a tool to use for human intelligence. It is not a substitute for human intelligence, but it can only be used to amplify it. So ultimately, it is we who have to use our minds to really give the answer, to see if there is fairness and justice in what we are doing and what has been done. So here we stand, and we are honored to have him as our chief guest and the speaker, because he insisted on talking to all of us because of the expertise that he possesses on the subject. Thank you, sir, for being here. Anytime you read something that you cannot understand, you can be sure that it's been drafted by a lawyer. They always try to get around what you think is right. But I will add one more thing, that a great lawyer needs to be a great author. And here we have Dr. Gautam Bhatia, who is a celebrity constitutional lawyer, academic, and a lawyer. He graduated from NLS Bangalore with flying colours, did his masters at Yale University, was a Rhodes Scholar at Oxford University, and did his doctorate from there. He came back armed with a lot of wisdom and expertise on the subject of constitutional law. And he is taking the world of litigation by storm at the Supreme Court of India now. His blog on Indian constitutional law and philosophy is widely read, as I know amongst my students who talk to me in class, and academics, and of course the Supreme Court has cited him so many times. He is a prolific author. He has written 3 books on very important issues of free speech, on the transformative constitution, and the unsealed covers, which I just saw one of our advocates carrying. He is also a great lover of fiction and says that that is his original passion. So he's written 2 books called The Law and the Horizon. Well, Dr. Gautam Bhatia, it is indeed a privilege to have you with us, because as and how constitutional courts grapple with different issues of constitutional law, we have people like you to guide them and bring clarity to the table. Well, he carries his boyish charm easy on his shoulders and is an iconic trendsetter to the young generation that we have sitting here amongst us. Thank you for accepting our invitation. Professor Balram Gupta is a sudden guest on the dais, but he is again a combination of a lawyer and an academic. Professor Emeritus, Senior Advocate, who is heading the National Judicial Academy of India, again has greatly contributed to the field of judicial and legal education both. Professor Ratan Singh, our former director, is a great sounding board because whenever I feel I have some question or problem, it is with blind eyes or eyes closed that I go to him. And he always has an answer. Professor Jaimala carries herself with great dignity and comfort and brings ease to all that is happening, the chaos that is happening in the department behind the scenes. Both Dr. Nidhi and Dr. Supreet have been the pillars behind this event, the organizing of this international seminar, have taken it to heart to ensure the smooth operation of this seminar. Our team, led by Yajur, Samiksha, Rajat, Swastik, Prerna, Arjun, I may be missing out some names, please forgive me, and also being ably assisted by our faculty, Tanya Singh, and by research scholar Pallavi, have contributed greatly to the success of this event. Thank you everyone, and I thank the participants for being here. You know, Stephen Hawking said that AI is going to be the best invention that humans ever make. But it could also be the last, unless we know how to control it. And I think that is precisely the reason that we are gathered here for the seminar today, to deliberate on the question of the legal and ethical control through the tools of constitutionalism and rule of law. How do we maneuver this new onset of technology of AI? Thank you very much. Thank you for being here.
Thank you, ma'am, for setting a delightful tone for the rest of the event. It's an honor for us to welcome our esteemed keynote speaker, Dr. Gautam Bhatia, Advocate, Supreme Court of India. Besides being an influential figure in the Indian legal landscape, he is also a prolific author. His unwavering passion for advocacy, justice, and fairness gave a pivotal significance for the protection of fundamental rights, including the recognition of right to privacy. For his achievements, he even made it to the 2018 Forbes India 30 Under 30 list. I invite you, sir, to share your words of wisdom.
Thank you so much for that very generous introduction. And it's great to be here and to be speaking about this issue and this topic. And often when we think of AI in the context of law, we don't normally think of AI at the intersection of constitutionalism. We normally think of AI in the sense of development, of innovation, competition law, those legal domains, all of which of course is extremely important. But there is also an intersection between AI as it is developed and practiced in the world today and the Constitution. So I'll begin with reading out a quote which I think really sums up that relationship. And it's a quote from a book called Automating Inequality by a scholar called Virginia Eubanks. A book I would recommend very strongly. It's a book that influenced many of us as we were in the process of of drafting some of the submissions in the constitutional challenge to the Aadhaar scheme many years ago now, 6-7 years ago. That book really shaped the way that many of us in that litigation thought and approached these issues. The quote goes, and I'll read it out. Since the dawn of the digital age, decision making in finance, employment, politics, health and human services has undergone revolutionary change. 40 years ago, nearly all of the major decisions that shape our lives, whether or not we are offered employment, a mortgage, insurance, credit, or a government service, were made by human beings. Today we have ceded much of that decision-making power to sophisticated machines. Automated eligibility systems, ranking algorithms, and predictive risk models control which neighborhoods get policed, which families attain needed resources, who is shortlisted for employment, and who is investigated for fraud. Digital security guards collect information about us, make inferences about our behavior, and control access to resources. This, of course, would sound familiar to those of you who have happened to engage in your daily lives with automated systems, whether in banks or elsewhere. And each line of this quote speaks to a constitutional issue, or a set of constitutional issues. In the book, Professor Eubanks basically talks about how, when it comes to, for example, homelessness in the US, or placing children in foster care, or the surveillance of neighborhoods, when those decisions are outsourced to algorithmic processes, to artificial intelligence, then often the result really in many ways impacts core constitutional values of equality, discrimination and so on. Now, the question that you might ask when I say this is, in what way is a value or a constitutional value like equality or discrimination in any way relevant to the operation of algorithms or AI? Because obviously, unlike human beings, so one would think, an algorithm or AI cannot be biased against X or Y group. An AI cannot intend to discriminate. An AI will not come with pre-existing baggage, prejudices on grounds of religion, caste, sex, and so on. That's what we think. And for the longest time, the constitutional doctrine of equality actually was responsive to this kind of a thought process. Because classically, the idea behind the constitutional right to equality was that if you are claiming discrimination, you must demonstrate who it is or which individual it is or group it is that is doing the discrimination, and you must show that in some way the conduct flowed from an intent to discriminate. It's not just something that happens as a coincidence, or not something that happens as a byproduct of something else. That was classical doctrine of equality as originated in the US and was exported all over the world, and it still exercises a very dominant view, dominant pull on understanding of equality and discrimination. We think that there has to be an actor, an entity, a person, someone who is doing the discrimination that we then complain about. When you outsource those actions to a non-human entity, then where is the possibility of discrimination? That is the way that we think. Now, interestingly, of course, as you all know, Indian constitutional doctrine has, from very early on, not subscribed to that intent-based idea of discrimination or equality. Even before independence, when interpreting the old Government of India Act, 1935, Section 292 of it, there was this idea that what you must look at actually is the effect of a policy, an action, a law, and not the intent behind it. And soon after independence, in the Bombay Education Society case, that proposition was reinforced. It was further entrenched in 1960s, Supreme Court in a case called Khardige Shambat, and then it goes on in that fashion. Most recently, in the Navteej Johar case and other cases, the doctrine is that what matters when you're looking at a violation of equality, potential discrimination, what matters is the effect and not the intent behind whatever act was done. And this, of course, makes sense in the Indian context, where often in our history, the worst forms of discrimination and inequality have not been as a result of an individual acting in a certain way, but the result of social structures, institutions, patterns of behavior. And so in that sense, Indian constitutional equality doctrine has always been well equipped to deal with the kind of issues that arise when it comes to the intersection between AI, algorithmic decision making, and constitutional law. In fact, the kinds of issues that were raised by Virginia Eubanks in the quote that I began with. And this must struggle against another attitude or an approach which is broadly called automation bias. Automation bias is a phenomenon where we naturally think that because an AI or an algorithm cannot, by definition, be biased, therefore its decisions or the outcomes that come out of an algorithmic process, therefore a presumption of fairness, of equality, and so on. So this is something that's been studied across the world and empirically proved that there is this thing called automation bias, where we intuitively think that if something is the result of AI or an algorithm, then it's more likely to be fair than a human being making the same decision. But that really, if you think of it a little deeply, doesn't really work, because the output that comes from the AI or the process or the algorithm depends upon the input that goes into it, and the input is always fed by a human being. So in that sense, those biases are translated forward. Now I'll give you a couple of examples of that. So take one example. Right? So in August 2018, 5 or 6 years ago, there was a report in the tech magazine Factor Daily, where the Chennai police, and I think this is now being used all over the country, were using a system called Face Tagger to surveil a busy marketplace. And what they would do is that they would use that Face Tagger software to just look over the marketplace and then query the results with the existing database that they had of people who had been accused or charged or convicted of criminal offences. So that was, and then they would say, okay, look, here is, we have done this surveillance, this dragnet surveillance in this marketplace, and here's a match between this person who's there and our database, and therefore we will take certain kinds of action. And the CEO of Face Tagger in an interview said, and I'm quoting his words, that a guy walking on the road at 2 a.m. Who is looking suspicious could be photographed by the police and his identity cross-checked with the criminal database. And now, of course, the law then turns upon what to think of as someone who looks suspicious, and that's where the issue of the existing biases, prejudices comes in. Right? So this is part of a broader set of technologies called FRP, or facial recognition technologies, which you would all have heard about, at some point of time. And there are there's a long-standing debate over the use of FRP. It's used in policing, it's used to prevent crime, it's used to check crime investigations. And there are many critiques, and this is an ongoing debate. There is present pending litigation in the Madras High Court and in the Telangana High Court, because in Hyderabad this is used a lot. That deals with those issues and subjects FRP to constitutional standards. That's ongoing. But if you look at the data that has come, and this is primarily from the US, in studying FRP, what the data shows is that the accuracy of FRP, and therefore its ability to function effectively, neutrally and fairly depends upon the training data that it is fed on. And in the US, what's happened is that the racial biases of the people or the individuals who feed in that training data is then reflected in the output. So it is found, for example, that the FRT technology is far more likely to accurately identify a white face as opposed to a face that is black or a person of color and so on. Therefore, making the possibility of misidentification and in turn coercive or punitive police action more likely if you are non-white than if you are white. So that actually shows you how automation bias, which is the assumption that if a machine is doing it, it is neutral and fair and unlikely to be biased, runs up against the reality where the black box, which is the process through which the input data becomes output data, is where actually the bias in effect takes place. And that again shows you the inadequacy of the classical equality model, which makes it to show some kind of an intent. So for example, in the US jurisprudence still, under the Constitution, there is no recognition of inequality in effect. You have to show a certain kind of intent behind the action, the state action, and identify who the person is who is doing that action. Whereas under US statute law, after a case called Griggs, it's now established that the statute provides for this equality in effect, then you can use that. In other countries, the UK, South Africa, these states, there is recognition that discrimination can often be a function of effect. But again, the constitutional test then is somewhat lightened or loosened for assessing those cases. Now, again, the facial recognition technology example is actually a classic case of the intersection between constitutionalism and constitutional law and AI and technology and algorithms. And in fact, as I said, there is pending litigation that actually demonstrates that connection. And so as you all know, the test now under Indian constitutional law for assessing fundamental rights violations and testing if a restriction is reasonable or not is the proportionality standard. Right? So, and this standard has 4 limbs. The first limb is there a law, existing law, that sanctions the rights violating state action? That's the first step. The second step is that is there a rational nexus between the rights restricting state action and the state goal? The third step is whether the restricted action is the least restrictive possible action. So is there an alternative that achieves the same goal substantially but is less invasive of fundamental rights? And the fourth prong is on a balance, is the intensity and the importance of the state goal adequately balanced by the extent of the invasion? There are the 4 steps, and now after the judgment of the Supreme Court in Gujarat Mazdoor Sabha, the 5th test of procedural safeguards. So adequate procedural safeguards that exist. Now you can see how in the FRT case this whole issue of algorithmic bias, AI models, black boxes intersect with the Constitution. So on the first step, often interestingly there is no law that exists. These are often executive instructions through which this happens. But that's not really a question of the AI itself. In the second step, is actually because of the distortions that occur in the input data and how it then impacts the output. There is a strong critique that actually FRT does not fulfill, by definition on its own terms, the goal of adequate prevention and checking of crime. And there are the statistics that show the error rates of FRT when it comes to certain kinds of faces, based on racial ethnic distinctions, is actually demonstrating that on the second step, the distortions that occur make it constitutionally vulnerable. Of course, the third step is important because the argument then is that okay, eventually FRT will improve enough to eliminate these errors at least to a degree where there is a rational nexus between the goal and the step. So that the third stage asks that are there less restrictive alternatives, and then of course the question is that are there other ways of policing that do not invade privacy to this extent, but are sufficient to achieve the goal of adequately preventing and checking crime. And then the fourth step is that given the existing demonstration that there are equality and discrimination issues in any kind of software of this kind, is that worth then the invasion of rights that follows and the goal. So you can see how the arguments in this kind of a case really implicate that intersection between technology, AI and the Constitution. I'm not saying that one of the answers is right. You may come down on different sides based on your assessment of the four problems of the constitutional test, but what is sure is that you must engage with these issues and see how the use and the design and structure of AI affects constitutional rights. And again, this is summed up in a really pithy way by Virginia Eubanks in her book. Again, I quote the paragraph that I think really again sums up. I began with it and I'll close this part of my remarks with this. Is that rational discrimination does not require class or racial hatred or even unconscious bias to operate. It only requires ignoring bias that already exists. When automated decision-making tools are not built to explicitly dismantle subtle inequities, their speed and scale intensify them. So, the argument is that given the speed and the scale at which AI operates, if you don't actively account for biases in the design, then they will get entrenched at even a greater speed and rate and scale. And so now actually, for example, in the EU and in those countries, there is a requirement of factoring in the possibility of non-discrimination, of equality and so on into the design of the AI, and then that will then, you have to actually demonstrate you're taking into account before you, go ahead with it. And the other interesting thing actually is, and this takes me back again to the beginning where I said that in many ways, the change has been that where initially these decisions are taken by human beings, now they are taken by machines. There is actually a rule or a norm in EU law, which is a right to being processed, your information being processed by a human being. And so, for example, before say your welfare can be cut, before say your rights can be impacted, you have a right to a hearing that involves a human being on the other side. So the final decision cannot be taken by AI or by an algorithm. There is that explicit right that's there in EU law. The other point I want to make in this regard is that we often think of this being something radically new and radically different and completely not subjected to existing models, or history can't teach us much. But I say that is perhaps a bit of an error, because in many ways the issues that I have raised today and discussion does have historical antecedents in many different ways. So for example, when I talked about Face Tiger and the CEO's description that someone who's looking suspicious, the algorithm will just take a snap and match it and so on. This actually is reminiscent of many of the colonial laws we once had and in many cases still do. For example, we had these acts called the Beggary Act, which still exists in many states. Recently in Delhi and in Jammu and Kashmir, they were struck down a few years ago, 4 or 5 years ago. And one of the provisions of the Beggary Act actually was that if there is someone who you see who is wandering around without any visible means of sustenance, then that person can be taken into preventive custody and detained. The idea was that the British wanted to basically turn everyone into wage labor and productive wage labor. So those groups or tribes or sets of people whose lifestyle was nomadic, whose lifestyle was meritocratic, who would move from place to place, and therefore were not subjected to British policies of labour and taxation, had to then be brought into that circuit of labour, tax, and so on. And so the British basically criminalized just the appearance of being without a visible means of sustenance. And that, of course, was conducted by colonial officials. And now the same thing you can see is just outsourced to AI. And so in that sense, these issues are not new, and they have been coming up in different ways. So in that sense, you must be aware of the history and see where it is that AI actually is being deployed to recycle an old history which you do not want to relive. One more example, and also involving algorithms actually interestingly, is that many people think that platform work or gig works, Uber, Swiggy, Zomato and all, is a completely new form of labor which cannot be subsumed within older forms, because look here, the worker or the laborer has their own equipment. They don't work for one employer. There's no one factory space, and it's they can log off whenever they want. So you have all the arguments, right? And of course, the algorithm or the app is the centerpiece of that. The app is what brings you on board, both the consumer and the worker, and then the app is what disciplines the workers or rating systems and can take them off and so on. So we know all that. But interestingly, if you look at some of the early labor law cases in Indian constitutional history, they involve the rights of BD manufacturers, specifically women who were centrally part of that industry. And if you look at the facts of those cases, apart from the algorithm and the app, actually it is quite similar, because there as well, there was no factory. The leaves would be sent to the homes of people, where they would then roll them into the BDs. It would be piecework, so not like it wasn't monthly or annually. It was per piece, so much like per ride you get your money, so per piece. And the employees or the workers could work for somebody else as well. But the Supreme Court said, look, this is all fine, but ultimately it's a question of the amount of control and power that the employer or the owner of capital has over the worker. And that's what we'll go by. And they said that you have to give these workers labor protections. So in that sense, now of course we have the app, we have the Uber app or the Swiggy app, Zomato app. We have AI which runs that app, which makes those decisions on pricing, on distances, on routes and so on. But ultimately, when you come to the issue of exploitation of labor, of management, of control, the issues are the same. The app and the algorithm often distracts us from the essential continuity in those terms. That's just a bit of an aside. Now, the other thing I want to bring up for your consideration is that there is another way in which automated identification systems implicate questions of equality and discrimination. And that is to say that in many contexts, what automation does is that it tends to freeze its targets in time, portraying them as just, at one point of time what they are. I'll explain what I mean by this. So one common phrase that you would have heard is something called predictive policing. So that is a phrase you would have heard often, where on the basis of a person's past profile or various other indicators, there is a profile drawn up, and the idea being that you want to prevent a future crime before it happens. So you profile a person's past and to predict how they might behave in the future. And this is exactly, of course, what the face tagger app we had discussed earlier was doing. So the idea being you investigate even before there is a crime. It's the same thing that happens in credit scores, automatic credit scores, and other factors of this sort, DNA banks and so on. So the problem, of course, is that human beings can always adapt and evolve, whereas the mathematical models that exist on the basis of this kind of predictive work are based on the past assumption that these patterns will repeat. And in many ways, it's actually been seen that, for example, in the US often, these decisions, for example, on credit extension and so on, are made on the basis of, say, postcodes or neighborhoods. The idea being that, in this neighborhood, there's a history of a certain kind of defaulting or whatever. And often, if you look at it a little deeper, that is the function of previous discrimination in terms of often racial ghettos or segregation on grounds of race or class. And so these are past discriminatory actions that then feed into present patterns. But the AI only looks at the present patterns. It doesn't take into account what happened or the basis of those. And on that basis, as we discussed, it often entrenches or tends to perpetuate existing discrimination, existing inequality. That's one other issue that rises in terms of the intersection between the Constitution and AI technology and algorithms. The final point, and that's connected, of course, to the points we have made before, is that often the use and deployment of AI or technology or algorithms can result in serving as a drawbridge or as a gate that deprives individuals of access to entitlements, benefits, rights, and so on. And that's what we discussed when the EU has now actually had a rule that says that there must be a hearing, a personal hearing, before you can deprive somebody of their rights on the basis of an algorithmic decision that they're not entitled to X or Y right. But still, the issue there is that in all these cases, once the AI has made a decision, initial decision, or whatever it is, the burden of proof then often shifts the individual to show that they are who they are or that they are entitled to their rights. For example, if by operation of an AI software you are deemed to be dead, not alive anymore, trying to prove that you are alive, it can often be quite difficult, and there are many humorous stories about that. But basically, the idea is that often because of the operation of AI and because of automation bias, once that initial decision is made by the AI, by the algorithm, by technology, to strip an individual of certain set of rights or create a context or situation where the individual is no longer entitled to something, then disproving that becomes a very, very difficult prospect. So in that sense, the law and the Constitution have taken into account the problems that arise in those kinds of situations, in those kinds of scenes, and that we've seen happen multiple times. Of course, Aadhaar is not an AI model, it's biometric identification model, it's a very basic algorithm. But it shows you the kind of issues that arise as you go up the scale and complexity. So when, for example, in Aadhaar, and it may happen to some of you, if your fingerprints don't match, it's often hard then to be able to convince whoever it is that this is who you are. And it's harder as you go down the socioeconomic scale. And when you now scale up that kind of a software to higher levels, the difficulties often mount. So in that sense, there are these issues that arise. And one possible solution that's been mooted again in the EU to these issues is something called the right to a source code, which is that if on the basis of an algorithm, on the basis of AI, you are taking crucial decisions that impact people's rights, then you must open up the source code that underlies the algorithm for public scrutiny or public audit, right? So to show, okay, look, this is how it operates in practice. There are two issues with this. One, of course, is that this is very technical, and for most people it's unintelligible, so you can't really figure out what's happening. You're just given a source code. The other is that when you try and make this argument in the context of private companies. So, for example, if the argument is that, and the argument has been made in the US, that the algorithm that Uber uses to assign rides, to have surges, to determine price is actually biased. And the argument made is that Uber must open up that source code for public scrutiny. Uber's argument is that competition law, our property rights over the source code preclude us from revealing it. And so again there, the constitution has to draw that balance. Where is the balance between the right of platforms to maintain proprietary interests over business information vis-a-vis the rights of the people to know the basis on which these judgments are being made, which impact people's lives, and given the influence that platform companies have, this is obviously not simply a private decision. It has wide-ranging public impacts, and there again, constitutional jurisprudence on when a private body performing public functions should be subjected to constitutional norms becomes important, right? And then that becomes a ground for actually arguing that even private corporations should be subjected to constitutional norms, right to information should apply in certain contexts and so on. So that balancing act cannot be done without really looking at the Constitution, how the Constitution works, and intersection with the Constitution of questions around AI algorithms and so on. So I see I have 5 minutes left to finish, so I'll just make 2 points by way of conclusion, or 2 ideas I think that are constitutional ideas, but which are really closely, I think, linked to this discussion. The first is something called the culture of justification. So this is a phrase that comes from South African constitutional law. The idea being that in the pre-constitutional domain, we broadly had a culture of authority, where authoritarian governments and the executive and the public power holders were not compelled to explain the basis on which the decisions were made that would impact people's rights. So it was just an autocratic top-down rule. The fundamental difference that our constitution or constitutionalism makes is to replace that with a justificatory culture, which is that every public action, every action that impacts people's rights, whether taken by elected officials or not, must be explained with public reason. So what is the basis of this? And what we've discussed so far, and the issue of the black box and the way that input data is distorted, within the black box, I think really pushes us to extend this idea of justification and this culture of justification to the decisions being made by AI in these domains of welfare, housing, crime, and so on. So there must be transparency and scrutiny of the way in which the decision-making process works. Because as you've seen, that's where often the bias comes in the process. The bias in effect, the bias in impact, even though there's no intention or no single body. That's one, I think, a broad principle I want to put out there for you to think about. And the second thing is something called technological self-determination. And so we know self-determination as a concept, in international law, the right of individuals and peoples to determine for themselves, their future, and that also applies to various constitutional rights like privacy and so on. In the case of technology, AI algorithms, it basically says that individuals must have the right to engage with these systems on their own terms, and the right to opt out of these systems without being penalized for opting out. Right? So something like GIASA, a very common thing in every area. Right? So I should be able to opt out of that, have a meaningful choice to not be processed by an AI system and not be penalized for opting out. Right? So that is every individual must determine for themselves how they will engage with these AI systems which impact their rights. That must include the right not to engage as well. So these are the 2 ideas I would like to leave you with, and just to think about how they might intersect with constitutions. And in closing again, I think that while the dominant discourse around AI is the discourse of innovation, competition, development, we must think about the manner in which presently the deployment and use and control over AI affects constitutions. Right? I think that it affects them in quite a deep way, in many interesting ways. So with that, I will close and thank you.
Chief Guest, Honorable Justice Anup Chitkara, Judge Punjab and Haryana High Court. He has a key expertise in criminal law, constitutional law and न्याय. Being himself a strong advocate for extensive utilization of technology for advancing the rule of law and justice, he is continuously working with an objective of digitalization of the legal system. Please join me in welcoming him.
सर आप इधर आ जाइए किसी ने कंट्रोल कर दिया सर I'm controlling okay I'm just standing in for this only sir so he's standing down so good
It'll just take 2 minutes to settle my system. It will take some seconds. Thank you for having me here, and I welcome Dr. Balram Sharma, Dr. Balram Gupta, who is my mentor, and it is a sweet surprise. Dr. Gautam told about two main things: biases, intellectual property, vis-a-vis constitutional rights. So, Dr. Gautam, I had a bias. My bias was that I knew that you are going to, in case I follow your topic, I will be fighting a young Muhammad Ali. So different everyone. So that's why I have opted for a very, very different topic. And I want to demonstrate how AI works, so you can see the translation. And if you practice, it improves. So all of you can see the translation going on, the script going on. This is just to demonstrate to the young law graduates, lawyers, that how you will be saving money on your typists, on translation, and you can translate it into any language of the world. And how much it costs? Just Microsoft Office 5,000 rupees. If you buy a single unit, it costs only 1,400 rupees. So no need to buy a Dragon for 55,000 rupees. You need an internet connection and a licensed software. So let's. So I'll just move it here with you, all of you, so that, is it working? Is it working? So I will take you through the journey of growth of human beings towards artificial intelligence, and then a bit background about introduction to AI and the world. When we started global thinking, we started in way back, not recently, 100,000 years.
As we can read it.
Look, needs to be kept closer.
I know.
The first milestone is when the Homo sapiens invented, discovered fire. So this fire, how much it changed, and look at the time it was taken for the fire to change. So now, after that, the next milestone was wheel. Wheel made the world connected. Without wheel, can you think of commutation? Can you think of traveling from Ohio to Chandigarh or anywhere? So this is the next milestone in human history. So after that came language when it is scripted. This is a very old, it's the first discovered language in southern Mesopotamia, Sumerian language, 3100 BC. So this was written on the rock. So if you write something on the rock, if you commit one error, your entire rock is wasted. So that it was a limited technology, but it didn't work. So how it was then? After that, somebody have to move the slide. Yes. So paper was invented. So paper was invented in China 2000 years earlier. It was made of silk. It was made for. Don't we have a volume here in this speaker? The TV speaker. इसका टीवी का स्पीकर नहीं So the volume is not volume, so I will show you the audio also. So this is the paper which is discovered 2000 years ago, made in China. This is preserved. Look how paper changed the technology. Everything which we were memorizing, we could write it down, and once we could write it down, we were able to follow it, take it further. Even now, it is the paper which has brought all this knowledge together. So from the paper, the next movement is, just move on, Soumya, please move the slide. Its range is not there. So now, machines, industrial age started. This is the next milestone of industrial age. We started, instead of writing on the paper, we started typing on the paper through a machine. And how now in the meantime the power has also started. So how the power started? This is the electronic typewriter. How the power added to the machine, and it's a combination of machine and a power in the machine. So how the things change? It had, this is the first electric typewriter. It had the capacity to align, remove small mistakes that time. And after that, another milestone came, personal computer. Now things change. So this is how the journey is starting, and this is first PC, 1981, IBM USA. Then from this journey we have the latest all-in-one computer, PC, software in this, all these microprocessors and outstanding computers. It is million times stronger than the computer which had taken Apollo 11 to the moon. So and everybody has it. So this is how the exponential growth in technology took place. So I put a quiz. Now, are you ready to answer?
Yes.
So who is the father of computer? What is it? Who have to raise hands? Otherwise you will be disqualified. I was disqualified from Mr. Babu. So, tell me, who will raise hands? Okay, you tell me. Yes.
Charles Babbage.
So who agree with him? Those who agree with him, raise your hands. So many. So all of you have won third prize. So who are the first prize and second prize? So tell me. Give me the prizes. So I will give you prizes. In the end, you have to stand here. So who won the first prize? First prize is a technician. Where is he? Without him, it's not possible. So sir, you are on the first prize. He was not one the technician. Who won the second prize? Tell me. Guess. A prize for this prize. If you answer this, I will give an extra prize. So second prize is to my mentor. So those who have won the prize means right answer, you will not know speak unless nobody knows the answer. So all of you, I will give you prizes here when the session is over, right? So now let's start. So those who have answered will have to now answer. What is www? Yes, tell me, madam. Okay, so who are these with World Wide Web? My God, all chocolates will be over. That's the right answer. So now let's move to third. So what is this? Now this is a difficult question. The name of the new parent company of WhatsApp, Facebook and Instagram. You all also know. Yes, madam.
So deep data.
Oh, that's right. Who sees it, madam? Oh my God, everybody is watching. So now, URL stands for what? Yes. Yes, madam. URL.
Uniform Resource Innovator.
Who agrees with that? All chocolates are gone. So, and what is this chat GPT? It uses which technology? Natural language processing. It's a difficult question. Natural language processing, artificial intelligence, text analytics, basic technology.
Natural language processing. Natural language
So, who says natural language production?
processing.
So, who? Alright, and who says artificial intelligence? So, let's see what is the right answer. AI. So, someone says, first, no problem. So, no problem. Which is an antivirus? Tell me all of these. CryptoLocker, I love you, Morris Brown, or Quickly? Quickly. Alright, so who are these is Quickly? So that's the right answer. So such a smart guy, right? So that's why I raised the standards. And this Mr. Gautam will answer, I think. So digital revolution is far more significant than the invention of writing or even of printing. So this is said by somebody who invented a beautiful thing. So what is in his hand? Tell me, can you name what is in his hand? Which device? Raise your hands. One answer. Yes, sir. 1 minute. Computer mouse. So we have the journey from typewriter to a computer to all-in-one to laptop and to your iPads. So this is how exponential the things have grown. Late 90s, 1970s, electronic typewriters to 2020 we have this technology, 50 years. Why the exponential growth is? Why is the exponential growth? When humans started beginning, say 200 to 5,000 years, there is a study that maximum number of people humans will meet in their lifetime was 150. So the knowledge will be, whatever they would learn will be lost. They would have invented so many things but would have lost because it was never complete. So this is now the world globe is wired and connected. So when you are connected, the entire globe works as a brain. So it's a multiplication of brain which is leading to exponential growth of technology. So that's why it is growing every day faster than the previous day. So now we had one part of the journey, let's see the other part of the journey, from wings to wires. So initially communication was through pages, everybody knows, right? Then we came to this computer, then in which it had an internet. And then it started with this internet in a better way. And then it was the first series of connection, it was used and discontinued, it didn't work. And web takes the flight. So without web, it is impossible for everything now. We are so connected with web. So this is how the dial-up processes started. And this is now in case we had a sound, if I would have shown you, you would have heard the sound when I had started practice. This is how I was connecting to the internet. We had to dial like a telephone and then it would sound like a phone connection and it was very expensive. So how it would be connected with great difficulty, like just like your phone is connected. Something next slide. So this is the revolution, then it came to broadband revolution and then we again moved to next slide. Don't use this next, you can use the slideshow straight away from here. Use this button, this only. It's not easy. Go for this. So change is the only constant. nothing is constant except for change. So it means change is something which is realistic. Without change, you are dead. Now we go to Indian legal system. We are planet's most populated country. And this is how we have papers. And these are the real photographs of our High Court. Even now. These are not, don't jump, yes. So these are the real photographs, we are 100% digitalized. But we have not adapted the technology. So these are the real photographs which we took. So now this was a journey from paper to paperless. All of us know these tools, Microsoft Word, I am using Microsoft PowerPoint. This is what I am using right now. And these are all AI based. Now this is artificial intelligence which is working. And now this is what we dream of our High Court. Maybe this year, this is what we dream, that how it will work. So paperless courts have an advantage, PD disposal, certainly. And now we go to another quiz time. Okay, so which are the examples of cloud storage? Raise your hands. Yes, you can.
Sir, all of the above.
Okay, who agrees with all of the above? So let's check the answer. Why you, yes, press all of the above. Mouse, use mouse, madam. Use the mouse, yes. So that's the right answer. You want the right answer. So, technology leads, others follow. Others include law, others include everyone. Who leads with the technology? Right from fire, right from wheel, and right up to anything. So why should law students know about it? Okay, answer. Who will answer? Yes. Who will answer? Please tell me. Other than going to ask someone, please raise your hand. Yes.
For better efficiency in research work.
Anybody else? Anybody else would like to answer? Draft legal documents. That's right. Yes.
So because it can replace us in the future.
That's right. They are right. It won't replace us. I will demonstrate how it won't replace us. Anybody else?
As AI will exchange, so if we don't evolve, we'll perish.
Now, can you speak it again?
As AI is the next change, so if we don't evolve and adapt to AI, we'll perish.
You will not perish. Don't
As
worry.
society,
You will be like a very ordinary person. That's it. You will sit on the, not in the lead. That's it. Anybody else? Yes, you will.
For translations in legal judgments and
Yes, good.
because time evolves, law भी बदलता है तो crime भी AI से होता है तो AI नहीं पता होगा तो फिर कैसे justice होगा?
So, this is one of the best answers.
So according to me, AI helps us to broaden our research on various subjects, including mathematics and science, which the lawyers are usually not used to using in their research. So using AI can help us broaden our research in those areas as well.
This is also right answer. There are so many perspectives. All the perspectives are right. One way or the other. So anybody would like to add anything?
Sir,
Yes.
just like Janvi said that AI, if you don't know AI, they might replace us. But as lawyers, we should know who is our opponent. So to know our opponent better, we should know AI.
Right. So Dr. Gautam, she is also no opponent. So opponents. So okay, now where is Professor? Why should lawyers know about opponents?
Law students should know about AI because that's their future that they are going to interact with. They should be well equipped to deal with it.
And for you.
Yeah, because the law students, they really participate in administration of justice, and what I feel is bench and bar both should know about artificial intelligence, otherwise the future is only about AI.
So what you learn is those who don't participate and job. So what is it?
Better answer.
Yes. So law needs to keep pace with the new cyber world. Otherwise you will lose the race. It's a race which we have already lost. Law is the least performing laggard. So we cannot afford to lose the race. So there's a quiz. According to Elon Musk, who is Elon Musk? Okay. Anybody? 1 minute. Give the mic to him, please. Elon Musk.
Good morning, sir. Sir, he is CEO of Tesla.
Oh, that's great. So, okay, now answer the question. Who will answer the question according to Elon Musk? Don't use Google, okay? According to Elon Musk, when will AI become smarter than humans? 2059, 2029, 2049, 2039. Well, give the mic. Yes. And why?
Say by 2029.
2029, okay.
Yes.
And anybody
By
else?
2029 it will be smarter than every.
Okay. Anybody else?
It's 2029.
Okay. Anybody else? Yes, give it.
It's 2029 because he's already coming out with the cars which will get the personhood through the AI. So that's the thing.
That's an amazing answer. It is the right answer. The difference is just 1 year ago the projections were 2049. There is a jump of 20 years. And Elon Musk says AI will be smarter than all humanity. Not only one human being, all humanity. You have to go back.
So you work with it's happened from there.
Go back. Let me. That's what we are. So Elon Musk predicts it will never work then. Elon Musk predicts AI is likely to be smarter than all humans combined. It is March 13, 2024. This is how the transformation is taking place. So can you believe all of you, including Dr. Gautam Bhatia and students from Yale, all of them who are living 200,000 from Yale, 200,000 from Harvard, and so many universities, Dr. Balram, and AI will be smarter. Now imagine. So where are we leading? So this is why we should know about it. So artificial intelligence has two applications, two subsets, machine learning and deep learning. So I'm taking you through a journey. So AI has two components, machine learning and deep learning. So what is artificial intelligence? Okay, answer, couldn't answer. What is AI? So remember, if nobody answers, I'm going to ask.
AI is having.
Give a mic, please give mic. Yes.
Sir, AI is having much wider ambit comparatively ChatGPT and
What is artificial intelligence? I'm not saying comparison. What is
artificial intelligence basically just like a human brain, and we can say the replica of the human brain.
Okay. And is anybody else? Please, who would like to answer? Give it. Please.
Sir, artificial intelligence is basically the system which helps any machine or computer to predict or think like a human thinks. It's basically a brain for the machine as it is for the brain for human.
So machine learning is just a part of the artificial intelligence.
So I'm not saying machine learning, but artificial.
So artificial intelligence is where the patterns are created by itself and then the patterns are followed to come into conclusion. But if I talk about the machine learning, it's just the patterns are given to the machine and then the patterns will be followed to come at the conclusion.
That's also right. So, yes.
So artificial intelligence is a branch of computer science that focuses on data and algorithms that mimic the human mind.
That's a very good answer.
It is the science and engineering of creating intelligent machines, especially the intelligent computer programs. It involves analyzing the data and then processing it and making predictions or decisions which are new.
So basically it's nothing but an intelligent system created by the humans to destroy themselves. That's so just around it with it.
I don't agree. Totally disagree. It is not to, it is artificial intelligence is an assistant in cognitive. Not it's a servant, in nuclear form. You make electricity or you destroy human, how do you?
So artificial intelligence is a technology that mimics human intelligence, and according to the EU Act, which is one of the artificial act, it defines AI as it is a machine-based system that has a varying level of autonomy.
And this is also right. So anybody else? Yes, please give it to the yes. Yes, you have already answered one. Yes.
So the primary objective of artificial intelligence was to be convenient for the human beings, to make things easier for humans.
Now, I think it's difficult to remember the answers. So I put this question to artificial intelligence, that who are you? So let's see how it answered. So as per ChatGPT, now look at the difference. Now you are seeing your answers and see the answer of AI. Artificial intelligence refers to the simulation of human intelligence in machines that are programmed to think, learn like humans. Look at this alignment. What you answer, all of you, is anybody's answer closer to this answer? And it was generated in 5 seconds, rather less than 5 seconds. So this is a challenge which we are not to be afraid of, but we have to take advantage of. Okay, so quiz. Which of the, and only days you will raise your hands. Which of the following streams is closely related to AI? Sanskrit, mathematics, physics, architecture. Those who have not answered correctly will answer first. You have not answered correctly, you answer. So anybody who has not answered, a boy here. You have not answered earlier? No, wrongly. Or rightly.
Other question I have answered.
No, if you have answered, you will get early. So those who have not answered, you never answered?
So predictable.
So mathematics.
Yes. Sanskrit. So he says Sanskrit. So we have 2 options. He believes in mathematics, he believes in Sanskrit.
Basically, it works on the algorithms through mathematics.
3 answers mathematics, 3 to 1. Architecture, anybody for architecture? Who is for architecture? 2. 3, you are for architecture. You are for? And who are for physics? Anybody for physics? Physics is the wheel, you mentioned a wheel for physics. Anybody for, sir, what do you say?
I would say mathematics.
So let's see, let's check the answers. First one could be, I know, they all put Sanskrit. Sanskrit is for you. So now put architecture. So only 2 options, mathematics and physics. Anybody will go for physics? So how can Dr. Balaram be wrong? So what is machine learning now? Okay, anybody? Machine learning. So you are fighting with a system. Now remember, what is machine learning? Your competitor is AI. Give it the mic. So you are ready to fight with AI. Okay.
Let's use ChatGPT.
Okay. No, I am not using.
So explaining machine learning and deep learning together. So machine learning is basically us till class 12 that knows that what is syllabus is restricted to the books. What we have to learn is already provided to us. And then deep learning is us after class 12 knows that knowledge is not only restricted to the books but is multi-level. That we need to understand.
So let's see what AI has to say.
So in machine learning, when we say that first of all we give a prompt to AI, we give the AI to learn something. Then AI learns itself. AI goes by itself and learns a lot of things on its own.
Anybody else? You are fighting with AI. Okay. Anybody to fight? Dr. Gautam, look, they have lost hopes. In just one round, nobody is fighting with AI except 2 persons. So let's see the answer. So as per Google's bar, Gemini, now it has been renamed as Gemini. So I'm taking into different AI platforms. Now see the answer. I got in 2 seconds. 2 seconds. Machine learning is a type of artificial intelligence that allows software applications to become more accurate in predicting outcomes without being explicitly programmed to do so. Machine learning algorithms use historical data as input to predict new output values. This is what Dr. Gautam had said, historical data. That was the key word. But The AI used it, we forgot. So now let's move to further. This is the now basic where my target was to take. So we have reached the destination. Law is nothing but languages. Dr. Shruti said, draft and draft will to confuse. I say confuse the judge by any means. By drafting, by lengthy arguments, if those don't work, try other means also. So, now, law is nothing but language. And that is how there are predictions that the maximum number of job replacement by AI would be in government operation and number 2 will be in law. 47% jobs will be lost, but nothing will be upgraded because new jobs will be created. So existing jobs, 47% will be lost. So what are LLM? I'm very to answer now. Let's see who will be correct to AI. Or lost? Anybody? Nobody. So sir, 2029 is a bar dream, 2024 we lost. Look, anybody will try? So as per ChatGPT, large language models are types of artificial intelligence models designed to understand and generate human-like text. These models such as OpenAI GPT, generating pre-trained transformer series are trained on massive amounts of text data from the internet. They use deep learning techniques, particularly transformer architectures to process and generate text. Look at how scientific definition they have. And it comes out in 2 seconds. Now, as per Gemini, large language models are essentially computer programs that can understand and generate human-like text. There is a type of artificial intelligence program that's been trained on massive amount of data. That's what the large language model refers to. This data can include things like books, articles, code, and even conversations. By analyzing all this data, LLMs learn the pattern of human language and how to use it. So see the similarity, the code is the same. They use different language. And now third, Microsoft Copilot, which I am using as AI tool. This is Microsoft Copilot which is working down. So as per Microsoft Copilot, LLMs are fascinating category of foundation models that have been trained on vast amounts of data. These models possess the remarkable ability to understand and generate natural language, enabling them to perform a wide range of tasks. So can you fight a storm? When there is a hurricane, a storm, you can only take refuge in a shelter. You cannot fight it. You cannot pray to God. Nothing will work. What will work is to save yourself. So how do you save yourself? I will just tell you, Mr. Gautam Bhatia studied from Yale University. It is in Eastern Coast. Right, sir? Why all best universities of the world are in Eastern Coast? Harvard, Brown, Princeton, Northwestern, Columbia, Yale. Why? Because Eastern Coast of US is very cold. In winters, you have no time to go out. What do? You stay inside and study. So it's compulsive studies. So this is what you have to do. When there is a storm, go inside study. Become East Coast. So AI, artificial intelligence, AI is now immense AI. AI is artificial intelligence and AI is assistant incognito. It's something which is hidden with you, working with you, aiding you, helping you, nothing to worry. It is the best secretary, secretive secretary, who will not divulge your truths to anybody. A secretary you can trust upon. So now we go to the justice, how AI is going to benefit in justice. So speedy and transparent justice. This is the first thing. It will be speedy, it will be transparent. Transparency is an issue. People have no faith in judges, judiciary. That's why people keep on filing appeals and appeals. And in the court of Supreme Court, somebody has said that half of the judgments will be overturned. If the same judgment goes to different and the results are different, it's just like a casino. We have which roster will get the cases, the results depend upon that. Smart lawyers know it. So this is transparent justice, transparency. So it will be AI who will assign cases. to the judges. Looking at, suppose I do bails and my 90% of bails are overturned by Supreme Court. AI will warn the Chief Justice that do not give bails to the judge. He is very bad in it. If I do criminal appeals and 90% of appeals are upheld, and AI is on the that algorithm, it can suggest, it can guide. Second is, speedy justice means you don't have a cause list where the tariq pe tariq is going on. That Damini movie, which had this famous dialogue, tariq pe tariq, is 30 years old and still we have tariq pe tariq. Nothing changed. So this will be taken care by AI. Like when you go to airplane, you have seats. You take the seats. When the seats are full, they don't take you. I have gone to a district court in Santa Ana. So there I visited the court, this Ronald Reagan court, he knows. So there was an AI working. It was a slot system. You go and take a data to your place. And the time also. They say your time is at 10 or 11, but they give you only 10 minutes to argue, not lengthy arguments. We have another problem in our country. Young lawyers, the judges give 2 minutes, the senior lawyers, they give 20 minutes. Now, whereas a senior lawyer means you are an expert and now you can conclude in 2 minutes or under 1 minute. But the expectations are that if you are a senior advocate, you are a senior in age, then the judge will keep on listening to you endlessly, which is contrary to the system. So AI is going to take care of all that. You cannot get across the limits. So third is accessible justice to illiterate and blind, accused and litigants. Suppose is a foreign national who is trapped in a narcotics case. So Dr. Gautam, you have experience of criminal law. In criminal law, 99% cases of narcotics, the story of the police is, he was talking, when he saw us, he became perplexed. So they were not using software. So, and then convictions. There is data that 75% of small quantity where people were drug dependents have been convicted based on this unbelievable story. So this is, then another problem is suppose somebody is a foreign national and he does not understand Punjabi or Hindi. You are explaining your grounds of arrest, article, which article, okay. Your grounds, which article of the Constitution makes the detention illegal? Who will answer? This is a fundamental question. Which article, okay, there is a girl there. So, illegal detention, which fundamental right? Article 22. Oh, that's right, absolutely. Article 22. So, grounds of arrest have to be shown, but how do we understand the language? So, AI can be a tool. Immediately it can translate into the language which he understands. All the police sheet into the language which a person understands. A judge is from South India, he does not know Gurumukhi. A person is speaking Gurumukhi, straight away it is being translated to the language of his choice. So these are the next two. Then eliminates language restrictions. Then third is equitable justice through proportional sentencing. But the biggest areas where we are laggards in India are disproportionate sentencing. I have a database where the sentencing are disproportionate to 400%. 400%. More than that. It is so disproportionate that you cannot believe. And the judgments of disproportionate are by Supreme